the minority leader was one of the reasons why I petitioned, or my client petitioned for the removal of the Chief Justice. There was a huge count which mentioned his name and mentioned the acts that formed the basis of our petition. What was this count? We said he had set a precedent, in fact, a record in the court by being the only party or being the only person who within 2 hours was able to get a full panel of the Supreme Court presided over by the erstwhile Chief Justice to give him orders that by the scope of the application before the court, no court in the world in the common law jurisdiction will give him. Now, in the course of all of those proceedings and after, people who knew the two of them spoke to me and they said, don't you understand? That is his sister. The removed Chief Justice is his sister. When
sister in terms of
they come from the same place.
Okay.
1, 2, when her father died, the minority leader hosted her visitors, and people who were there called me. So in some of if I had attended the next proceedings, the next person against whom I was going to raise that objection was the Chief Justice. I said, all of these arguments we are having back and forth, and you are literally descending into the arena of conflict, is because somebody that you are close to is the plaintiff in this particular matter. Who was the plaintiff? It is Afenyor Markin. 2, there is now information coming out that there are services being rendered in the judicial service which are linked to Afenyor Markin. So
services being rendered?
Yes, certain services. I don't want to give all of those details because I have it, but it shouldn't look personal between me and him, that he's rendering those services and getting commercial profits from them, and huge ones. And so at this point in time, when Afenyor Markin is making it look like, okay, there's a national public interest aspect of all of this nomination process, and there's some dispute and all of that, it has nothing to do with a minority position. He sold it out to his colleagues to believe that, well, we all have to take a collective position against this, but it is a personal interest.
So in other words, you say he roped in the party, but the agenda is nothing to do with the party as a whole?
If you ask me, yes. And I'm saying that when we petitioned, there was every evidence to show that insofar as that aspect of our petition against Afenyor Markin was concerned, there ought to have been a definite finding on it. 1, we said there was no basis for the speedy fixing of that matter for hearing. Her response, and that is documented, is that no, there was a basis. And her basis was that, look, I had already issued a directive to the effect that election matters should be expeditiously dealt with. Question, was this an election matter? No. It was about cross-carpeting. So factually that's not correct. Legally it's not correct. 2, she attached that her directive, and this is a lawyer and the Chief Justice, where she attached the directive was dated December 2024. This case took place in October 2024. So as at that time, there was no directive. So it was clear that this was a person who was doing a personal favor. There was no rule of law. It did not even accord, there was no practice direction according to her. Her principles on the basis of which she fixed it, the circumstances didn't exist. And she plainly lied in her response. Why was that not a basis for her removal? That the person who represents justice in this country can literally look at us, lie on the face of her own paper, only because she wants to justify a position she's taking to favor a particular individual. And that individual now wants us to believe that, oh yes, there are real and genuine reasons why we shouldn't be having a vetting. The facts that we have show that you have an interest in her being there. And so he's crying louder than every other person because he has an interest in the woman being there.